Good afternoon and welcome. We hope this broadcast finds you healthy and safe. Thank you for tuning in to MSK's video pop-up series, where we discuss late-breaking news and issues that affect your business during these uncertain times. Today, we'll be hearing from Hilary Feybush, attorney in MSK's labor and employment practice. As companies prepare to reopen, there are mounting questions on a wide range of topics. Today, Hilary will discuss the latest guidance from the Equal Employment Opportunity Commission, otherwise known as the EEOC, regarding work restrictions with folks over the age of 65 or others considered high risk as it relates to COVID exposure. Now, over to you, Hilary.
Thanks, Doug. As some of you may be aware, throughout the pandemic, the U.S. Equal Employment Opportunity Commission, or the EEOC, has been providing guidance through FAQs on COVID-19 and the workplace in regards to compliance with federal employment statutes. Today, I'm going to be discussing the EEOC's latest update from June 11th, which provides guidance primarily relating to the employer's obligations as employees begin to return to work. So during the pandemic, we have heard the CDC explain that individuals aged 65 and over are at a higher risk of a severe case of COVID-19 if they contracted the virus. As employees begin to return to work, the CDC has encouraged employers to offer maximum flexibilities to this group of individuals, leading both employers and employees to wonder what protections this group has under federal law. For example, can an employer tell employees ages 65 and older that they cannot come into the office and they must remain working from home because the employer wants to protect these employees from contracting COVID-19 due to their high risk? So even though it is for a benevolent reason, the answer is no. The Age Discrimination and Employment Act, or ADEA, prohibits a covered employer from discriminating against individuals ages 40 and older, and thus the ADEA would prohibit the employer from involuntarily excluding an individual from the workplace simply because they are age 65 or older. What about if an employee age 65 and older asks for an accommodation to remain working from home simply because of his or her age, even though the office has reopened? Does the employer have to grant this accommodation? So unlike the Americans with Disability Act, or ADA, the ADEA does not include a right to reasonable accommodation for older workers simply due to their age. However, employers are free to provide flexibility and accommodation to these workers as the However, employers are free to provide flexibility and accommodation to these workers as the ADEA does not prohibit this, even if it results in employees ages 40 to 64 being treated less favorably based on their age in comparison. So it is important for employers to remember that although the ADEA does not require them to provide a reasonable accommodation solely because of the worker's age, these workers may have medical conditions that would allow them to request a reasonable accommodation for their disability, as opposed to requesting one simply due to their age. So the EEOC's updated guidance also addresses whether an employee is entitled to reasonable accommodation, such as working remotely under the ADA because his or her family member is in a high-risk category for severe illness from COVID-19 due to an underlying medical condition. So while the ADA forbids discrimination against these employees, it also does not require that the employers provide them an accommodation if they're non-disabled based on the disability-related needs of a family member or other person with whom that employee is associated. So as employees begin to return to work, some employers are requiring employees to be screened, such as having temperature checks. What happens if an employee requests an alternative method of screening for COVID-19 related symptoms due to a medical condition? How should the employer handle such a request? Well, the updated guidance explains that such a request should be treated as a request for a reasonable accommodation, which should be provided so long as it's not unduly burdensome. Employers in these situations essentially should handle the request as they would any other accommodation request made under the ADA. Similarly, the EEOC explains that if the employee's request for an alternative method of screening is for religious reasons, the employer should determine if such an accommodation is required under Title VII. So a new area that the most recent EEOC guidance touches on is pregnancy, as it now notes that under the Pregnancy Discrimination Act, workers cannot be excluded from the workplace involuntarily due to pregnancy, even if the employer wants to do so in order to protect the employee based solely on concern about their health in connection with COVID-19. So this is similar to the one that I just described in terms of the employees that are age 65 and older. Even though the employer has a benevolent intent, they cannot keep these workers involuntarily from coming into the office. In addition, women workers who are affected by pregnancy, childbirth, or related conditions must be treated the same as other employees who are similar in their ability or inability to work, including with respect to job modifications. The EEOC's guidance also cautions employers to be cognizant of COVID-related harassment against Chinese or other Asian employees, including those who are perceived to be Asian. Covered employers are advised to ensure their managers and supervisors are properly trained on not only how to recognize such harassment, but also how to address it if it occurs. The guidance reminds employers that harassment may also occur using electronic communication tools and may originate not only from other employees, but also from clients, customers, and contractors. Employers are also encouraged to remind their entire workforce that harassment is prohibited and will result in disciplinary action. Employers should also invite their employees who experience or witness such harassment to report it. What about if an employee is working from home due to COVID-19 and they send another coworker a harassing chat communication? How should the employer address that? Well, the EEOC explains that employers should take the same action it would have taken had that employee been in the workplace. There should be no difference. The pandemic has also caused daycare centers, schools, and summer camps to close, leaving many employees struggling with childcare issues. To help employers address these situations, the EEOC explains that employers may provide flexibility to these caregiver employees, such as telework or modified schedules. But the EEOC cautions employers to ensure that they are not treating employees differently based on sex or another protected characteristic. So, for example, employers should make sure that they do not treat female caregivers more favorably than male caregivers, as doing so could violate Title VII. So I will conclude with the EEOC's new guidance that touches upon whether there are any ways for an employer to invite employees to request flexibility in work arrangements in advance of the employees returning to the workplace. The ADA and the Rehabilitation Act permit employers to make information available in advance to all employees regarding requesting accommodations for a disability that they may need upon return to the workplace, even if no date has been announced for the return. The EEOC suggests that employers send a notice to their entire workforce that includes application instructions and an employer point of contact information, as well as a list of all CDC medical conditions that could place workers at a higher risk of serious complications from contracting COVID-19. The notice should also explain that employers will consider requests on an individual basis for employees who have the listed conditions or other medical conditions that may require an accommodation. Another option is that the employer may send a general notice to all employees prior to the return, notifying them that the employer is willing to consider requests for accommodation or flexibilities on an individualized basis, such as a modified work schedule due to child care responsibilities. In the notice, the employer should specify if the point of contacts differ depending on the reason for the request. The EEOC has confirmed that either of these approaches is consistent with the ADA, and the recent CDC guidance that emphasizes the importance of employers providing accommodation or flexibilities to employees who, due to age or certain medical conditions, are at a higher risk for severe illness if they contract COVID-19. So although the guidance does not create any new obligations for employers, they do reinforce the importance of following federal non-discrimination law as workplaces begin to reopen for business. However, employers are also reminded that they should review guidance and orders from state and local jurisdictions, as some may differ from the EEOC guidelines. So that's all I have. Thanks for tuning in, and back to you, Doug.
Thank you, Hilary, and thank you for joining MSK's video pop-up series today. These video sessions are intentionally brief without Q&A, and we hope that you do find them useful. We also must emphasize that the information provided is not considered legal advice, but a general overview, and each situation requires further and appropriate analysis. If you do have questions for Hilary or need clarification on anything provided today, her information is currently on screen. And if you need additional guidance from anyone else on MSK's Reopen Rapid Response Team, please email reopen@msk.com. Keep an eye out for additional pop-up videos in the coming days and weeks, and more importantly, please continue to remain healthy, remain strong, and remain hopeful. Thank you, and goodbye.